So welcome to another one of our webinars for workers and friends of community legal centres across Queensland and across Australia, because what we're talking about today is something that's relevant for people working in community legal centres across the country. My name's James Farrell. I'm from Community Legal Centres Queensland and joined today by Bridget Burton from Caxton Legal Centre, who'll be presenting on general protections. Can we begin by acknowledging the traditional owners of the lands on which we're gathered through the wonders of modern technology? Bridget and I are in the Community Legal Centres Queensland office, and so we acknowledge the Turrbal and the Yagara people as the traditional custodians of the area that we call Brisbane today. But we've got, as I said, people tuning in from around the country, so we acknowledge all First Australians traditional owners. We acknowledge elders, ancestors, and any Aboriginal or Torres Strait Islander people who might be joining us today. A couple of housekeeping things from me before I hand over to Bridget, our presenter. We are hoping to record the webinar and make a copy of that recording available to you. We'll also email around a copy of Bridget's PowerPoint and a couple of other resources that she'll talk about over the course of the presentation. You can ask questions as we go. Webinars aren't great for kind of conversational way of learning, but if you do have a burning question, there's two ways that you can ask it. You can press that button that looks like a hand on the control panel of your GoToWebinar software. There we'll see something that looks like a hand going up at our end. You'll be able to unmute your microphone or phone, and you'll be able to ask a question directly. The other way that you can ask a question is to type a question into the questions box on the GoToWebinar control panel. We'll be able to read it, and we'll read it out or paraphrase it or something and respond to that directly. A copy of Bridget's presentation should also be available on the handouts area of your GoToWebinar control panel as well, available now. I think that's all of the housekeeping things that I need to worry about. So let's get into the main meal here. So Bridget Burton coordinates Caxton's generalist legal practice and has got a whole heap of experience in a number of areas of general practice for community legal centres areas of work, but today is talking to us about general protections. Thanks very much to Bridget. Over to you.
Thanks, James. Okay, so this is my first ever presentation via webinar, and normally when I present anything I like to have a conversation with the people in the room, so if anyone does have any questions, please, I encourage you to post them in the way you've been instructed to post them. James will have to help me work out how to work through those. So I am at Caxton at the moment. I have been at Caxton a really long time, but I've just come back from a couple of years at Legal Aid doing primarily employment law and anti-discrimination. So when I'm talking through the, and I've got a couple of case examples at the end, those are clients that I've assisted, or de-identified versions of clients I've assisted across the two practices, Legal Aid Queensland and Caxton. So I have to coordinate a PowerPoint presentation and my own speaking, which is more complicated than what I'm used to. So general protections. Now, you don't feel like you need to take notes. I'm going to send you around at the end of this presentation an abbreviated version of what I'm talking, the notes I'm talking to. So my slides are just very simple, but there is more material coming. General protections provide a range of overarching protections to people in the workplace. They start to come into play in the pre-employment process. They operate throughout employment and at the point of dismissal. That coexist with other protections provided by both the Fair Work Act and other employment law legislation. So the general protections provisions offer employees a range of benefits, including a less complicated option for bringing anti-discrimination actions and an alternative to victimisation proceedings. They offer you, our clients, better remedies than unfair dismissal actions in many cases. They provide a reverse onus of proof for some parts of the proceedings, and we'll come to all of these in a minute. And they have a more friendly costs rule than human rights actions. So if you unlike unfair dismissal, you don't have to have been employed for any minimum qualifying period to be covered by general protection. So they cover the whole of employment, which is a really big benefit to people who are sacked very early on in their employment for things like, you know, an inability to fit in because of their disability. If you have a client considering unfair dismissal, bullying, or any other sort of discrimination action in relation to the workforce, I think you should always turn your mind to general protection provisions and whether they might offer an alternative option. Additionally, if you have a client who is exercising any other rights at work, I think it's relevant for them to understand how their rights are protected and what their options are if some sort of adverse consequence befalls them for exercising that right. And that's a conversation you might have around victimisation. If you've got a client, say for example, considering doing something about sexual harassment in their workplace, but I think it's important for them to have a sense of where the general protections fit into that as well. At the moment, the general protections provisions as they exist in the Fair Work Act are mostly only available to national system employers, which is basically everyone in Queensland at least, except for employees of the state of Queensland or a local council. We are likely in Queensland to get general protections for state employees as a result of there's a current bill on the Queensland Industrial Relations Act which would provide much broader protection for state employees, but that's a kind of watch this space at the moment. If you have a state employee client for whom you would have recommended a general protections claim, but for the fact they're a state employee, I'd suggest you have a look at the other protections. A lot of the time, the general protections provisions are not bringing in a novel range of protections. They're rather collating together and improving things that exist in other places as well. Just before we go any further, I'll give you a couple of client examples towards the end of this talk, but I'm not going to go very deep into the case law today. Most of you are probably aware of the bench books produced by the Fair Work Commission. There's one specifically for general protections. It gives you cases for and against nearly every aspect of the various general protections provisions, and if you're giving advice, you'll have to get yourself across what's in that material. What I thought I'd look at primarily today, so take you through the main general protections that we use for our clients, and then talk to you a bit about jurisdictional choice, because I think that's where a lot of people struggle with these protections, because they are duplicate protections to a whole range of other protections that you find in other legislation and in the Fair Work Act. So I think that the jurisdictional choice issue is a really big one, and I hopefully will show you how I work through that for my clients, and share with you some of the resources that I use to make those decisions with people. So, next slide. What are the general protections? So, you will find the general protections provisions in Part 3.1 of the Fair Work Act. Section 336 sets out the objects. So, it makes it clear that what they do is protect workplace rights, freedom of association, freedom from discrimination in the workplace, and they offer a relief for people affected adversely by the breaches. In addition to the protections laid out in the objects, there are also protections against sham contracting, certain misrepresentations, and a specific protection against dismissing people for temporary absence for their own illness or injury. The first major protection that comes up all the time, and is kind of the overarching one, is Section 340. Section 340 anchors a whole range of other workplace rights. It protects a person from adverse action being taken against them because they have a workplace right, they've exercised a workplace right, or they may exercise a workplace right. There are three critical elements to Section 340. First, adverse actions. You need to identify the adverse action. Second, it is taken because of a prohibited reason. Relating in this case to a workplace right. We'll get to discrimination as well in a minute, similar. Okay, so adverse action is laid out in a table in Section 342. Within that table are that tells us what sorts of adverse action are prohibited depending on who you are in the workplace. So I'm only dealing with employees and employers. and specifically adverse action taken by an employer against an employee. That's item 1 in the table, but there's a whole list of other types of adverse action that can be taken by and against various other players in the workplace. So an employer takes adverse action against an employee if they dismiss the employee, injure the employee in their employment, alter the employee's position to their prejudice, and those two middle ones sometimes cover the same sorts of conduct, or discriminate between the employee and other employees of the employer. So adverse action, you'll all recognise, is not always unlawful. It's fairly common for adverse action to occur in the course of performance management, restructuring, and various other permissible workplace activities. It will only be unlawful if it occurs because of a prohibited reason. So because of, and this is really important because if you're familiar with other pieces of discrimination legislation, for example, you'll recognise that the tests are different depending, the threshold test is different depending on which piece of legislation you're looking at. Fair Work Act asks us to look for the reason for the adverse action. Why was the adverse action undertaken? Very often, a protected right such as making a complaint is intertwined with an employee engaging in other conduct for which that employee is being disciplined, for example. So sometimes it's hard to isolate the reason for the adverse action. Section 360 says that where there are multiple reasons for adverse action, it will be covered if the reasons include the prohibited reason. The High Court has had a look at this issue and they've made a decision in the Board of Bendigo Regional Institute of TAFE and Barclay. And that case is one of very few cases about general protections that have made it all the way to the High Court, and it's worth having a look at if you practice this area of law. That's the case that tells us that the prohibited reason must be a substantive and operative reason for the adverse action. So what happened in that case is the High Court found for an employer it had taken adverse action against an employee for his conduct during his union activity, which is protected activity. So he'd sent emails as a union representative, but within those emails was content that offended the employer and for which he was disciplined and ultimately, oh no, I'm not sure if his employment ended, but for which he was disciplined. So the adverse action was injuring him in his employment. It was found that the protection for union activity did not extend to all conduct during the exercise of that activity. In this case, the offensive conducts about the employer were found to be sufficient grounds on which to take action against the employee, even though they were made in union correspondence. So sometimes it's really difficult to deal with this connection between the conduct and the action that has been taken. The Fair Work Act helps us out a little bit here. So this is where the reverse onus of proof can come in. Your employee client does not actually need to prove the because of component. It is the employer that has the obligation of proving the opposite, that the real reason for the adverse action was not a prohibited reason. It sounds great, but in practice, you do need a threshold amount of information and ideally evidence to argue the connection. But the reverse onus gives general protections actions a real advantage over other sorts of actions where this link is really hard to prove. How it works is usually an employer will produce the decision maker. That they bring the decision maker into the proceedings and have them explain what was really in their mind when they made an adverse decision. So if you're giving advice to a client and they don't have evidence of that connection, but they know the decision maker will be produced, well, what do they have that might undermine that decision maker's evidence, or what evidence do they have that the decision maker had some particular thing in their mind? Because if there's no evidence of that connection, the decision maker would expect to give quite self-serving evidence in a lot of cases. So it can be of assistance, but it's not the great saviour of a case that might otherwise struggle. So the next component is identifying a prohibited reason. So if you can identify that adverse action has been taken, you can put your finger on the substantive and operative reason for that action. You then need to work out whether the reason is a prohibited reason. Section 341 defines workplace rights. So a person has a protected workplace right if they are entitled to the benefit of a workplace law or instrument, are able to initiate or participate in a process or proceedings under a workplace law or instrument, or make a complaint or inquiry in relation to their employment. So workplace rights are found in a variety of workplace laws and instruments and can include anti-discrimination legislation, for example, the sexual harassment provisions. They include workers' compensation legislation, the Fair Work Act itself, and various other locations. There is a specific right to make a complaint or inquiry in relation to employment, both within the workplace and to an appropriate body. That doesn't mean you have a right to argue with your employer necessarily. The nature of your conduct in the course of making your complaint or your inquiry may become relevant, but you do have a right, or workers have a right, to make complaints and inquiries in relation to their employment. So this is one area where it does overlap with other legislation. And the sorts of workplace rights that we see people having difficulty exercising and where we get general protections inquiries include things like making a work cover claim. So quite often adverse action will flow from making a work cover claim. Making a complaint about bullying, sexual harassment or other mistreatment at work. If you've been working in a community legal centre for a little while, you cannot have not seen a situation where somebody has been putting up with sexual harassment for some time, finally speaks up about it and is disciplined for their attitude. So those are examples of really difficult to exercise workplace rights. Inquiring about underpaid wages is a classic situation that can lead employers to take adverse action. The number of people who have their hours cut for making inquiries with the Fair Work Ombudsman is really high. Taking maternity leave, so that includes in some cases being made redundant whilst on maternity leave, which is a really big problem, and exercising the return to work guarantee that exists in the Fair Work Act for people coming back to work having taken parental leave. And I'm sorry I've said maternity leave when I should have said parental leave. But it applies to both. The difficulty with maternity leave, I suppose, as opposed to most fathers taking leave, is that it goes for such a long time, and a lot of workplaces build out their employees while they're on maternity leave, which has been a big issue. It sort of comes in waves, I think, but certainly this year and last year we've seen a lot of that. Asking for flexible hours because of caring responsibilities, disability or age, and particularly I think where those flexible hours are because of disability, that it becomes an issue for a lot of people. And asking for workplace adjustments. So your right to request workplace adjustments exists in the Disability Discrimination Act if those adjustments are for reason of disability or under the Anti-Discrimination Act. But your protection exists, or one of the places that you are protected is in the general protections provisions under the Fair Work Act. So the next big general protection provision that we see a lot of is discrimination. The discrimination provision is found in section 351. If, like most people in the CLC sector, I think we have a handle on what discrimination looks like under the Anti-Discrimination Act and the various pieces of Commonwealth human rights legislation. We all know the definitions are torturous. It's difficult. They often don't align with what people expect from a discrimination protection. The Fair Work Act is prohibition on discrimination is quite different. It's much less complicated. It means pretty well what it says it means. So I've extracted it here in the presentation for you. An employer must not take adverse action, so adverse action again, against an employee or prospective employee because of that list of attributes that's there, and it's all the usual ones. Some attributes are not in there that you might expect, but it contains most of the attributes that your clients are probably seeking your advice about. Now, unlike Anti-Discrimination Act discrimination and the various human rights, and I've put Anti-Discrimination Act in here because we're in Queensland and it's where we usually work, but it equally applies to the same hideous definitions exist in the human rights legislation, so the Disability Discrimination Act, the Racial Discrimination Act, Sex Discrimination Act and Age Discrimination Act all pretty much have similar discrimination provisions, and in particular the comparative exercise that's necessary in order to make out discrimination under those pieces of legislation. So unlike Anti-Discrimination Act legislation, which asks us to compare treatment between the person with a particular attribute and another, often hypothetical person without the attribute, Section 351 uses the same phrases we've already talked about in relation to workplace rights. So an employer must not take adverse action because of one of those attributes on the list. So it's a wholly different test. You don't have to prove that someone else in the workplace with a different attribute was treated differently, or the employer can't come back and say, oh, but all of these other pregnant women have been treated just fine. It's got nothing to do with your pregnancy. The test is adverse action because of one of those prohibited reasons on that list. So I thought it would be useful to have a look at a case where I think it would be run quite differently depending on the two different jurisdictions. So this is an actual case, Wilkie and National Storage Operations Proprietary Limited. It's a case example that the Fair Work Commission uses in the General Protections Bench Book to describe their Fair Work Act discrimination provisions. So in that case, an employee, a woman, was transferred from one location to another location, so her position was altered to her prejudice, so that the other location was way less desirable, favourable to her than the location she'd previously been in. She was transferred because she'd left early to collect her child from school. She'd also taken time off to tend to the child when he was ill. In Queensland, under the Anti-Discrimination Act, with our troublesome comparator, and I don't know what it's, well, I do know a little bit about what it's like elsewhere, but in Queensland, the comparator that QCAT uses to for discrimination matters is really difficult. I think you would need to prove that the woman in this case was subjected to less favourable treatment because of her caring responsibilities compared with someone who had left early or taken sick leave entitlements for another purpose, such as their own illness. That's really hard to prove, that if she'd gone home to do something else, that they wouldn't have treated her in this way. Fair Work Act, and this decision said the decision was made to dismiss this worker because of leaving early and taking carer's leave. Her leaving early was to collect her son, so she was successful in this matter. So whether or not workers with other similar needs, or whether or not people absent for other reasons are treated similarly unfavourably, or whether they would have been permitted to do that, is not relevant. So you can see that quite often workplace discrimination matters. It's really, the comparative exercise is really hard. It's hard for all types of discrimination, and the different test here is a much more easy to work with. You just it is important to be aware that subsection 2 of section 351 imports exceptions and defences to discrimination that is found in other jurisdictions, but it doesn't import the definitions of discrimination found in other jurisdictions. So standard defences that come into the Fair Work Act include that the person, for reasons of disability usually, but include that the person could not perform the inherent requirements of the job, or that there are occupational health and safety reasons for discrimination. So those are pretty pretty common defences that are run by employers. Equally problematic under the Fair Work Act as they are in other legislation, so it's important your clients are aware that the defences are brought in to Section 351 but not the definitions. Now, if you've been paying attention, you will notice that this Section 351 is not the only reference to discrimination in the general protections provisions, and I, like most people giving presentations on this subject, have glossed over the other type of discrimination. So it's back on the list of adverse actions. So when there's 4 things on that list: dismissal, injuring employment, altering position to prejudice, and discriminating between the employee and other employees of the employer. So in that discrimination is different. That discrimination is the actual adverse action. And at this point, I'm probably losing some people because the 2 types of discrimination are theoretically quite different. The reality is, in practice, discrimination provision in 351 is straightforward, relatively easy to use and comprehensive. It's not normally necessary to also argue discrimination as the adverse action. But just be aware there are 2 types, and if you're reading through the legislation for the first time, you will be confused by the 2 types of discrimination. But don't worry too much about discrimination as an adverse action. Normally you can get your case in under 351. The next major protection, general protection, and the last big one that I want to cover today is Section 352. So 352 provides, it's very specific, it's much more specific than any of the others. An employer must not dismiss an employee because the employee is temporarily absent from work because of their own illness or injury. The protection exists when a worker has given their employer a medical certificate, normally within 24 hours of the start of their absence, within a reasonable time, and it's only for temporary absences. An absence is temporary if it involves, and there's a complicated way of setting this out in Regulation 3.1, and I'll send it around to you, but basically an absence is temporary if it involves no more than 3 months unpaid sick leave in any 12-month period. So an awful lot of people, if you've got paid sick leave, people have taken other leave, and then they've ticked over into unpaid sick leave, no more than 3 months unpaid sick leave in any 12-month period before that absence becomes other than temporary. So the other, and it's on the slide, but the other thing that Section 352 throws up is that dismissal and contravention of Section 352 will also involve issues of discrimination, may also involve issues of discrimination and the exercise of other workplace rights. It's an advantage of the general protections regime that it can bundle together a range of breaches of the workplace law. So other jurisdictions like unfair dismissal and the traditional discrimination jurisdictions do tend to isolate causes of action, which can mean multiple concurrent proceedings relating to different parts of the employment relationship. It's not, that's not perfect. General protections is not going to be able to bundle everything together. And one of the major issues for us is that there is no general protections provision for sexual harassment. You're protected when you make a complaint about it, but you're still going to have to go back to the Sex Discrimination Act or the Anti-Discrimination Act for the conduct throughout the sexual harassment conduct itself. So concurrent proceedings are not always avoidable, but Section 352, for the things that Section 352 covers, you will likely be able to bundle it together with other breaches, and that's the case for various breaches of the general protections provisions. You can chuck them all in. So remedies. Now, I tried to get my son to help me embed a GIF of Kanye West throwing money around to this slide, and we just couldn't do it. So I apologise for a very bland slide. But remedies, the orders that can be made by the Federal Circuit Court in relation to general protections are primarily compensation. So the amounts of compensation just seem to be going up. The annual report for the Fair Work Commission from last year had a number of over $100,000 amounts at conciliation stage. So those are big amounts of compensation. There is a table of outcomes available on the Fair Work Commission website for that you can have a look to get a sense. It doesn't tell you what the person was earning beforehand or how strong their case was, but the outcomes being achieved by conciliation under the general protections provisions are quite substantial. Reinstatement is possible. Reinstatement has for a long time been called the primary remedy, but it really isn't. Very rarely is reinstatement the remedy. It's possible where there's a large organisation. It's nearly impossible for smaller or middle-sized employers where you can't replace that person into a different physical location. So mostly we're looking at compensation as an outcome. To get your compensation for your financial losses. There's also hurt and humiliation, damages for hurt and humiliation, as you might expect to find in a discrimination case. You can get paid for your payment for unpaid entitlements. There's interest and pecuniary penalties. I think that the pecuniary penalties are primarily ordered where the Fair Work Ombudsman's brought proceedings, and certainly you don't get that necessarily at a conciliation, because pecuniary penalties are a matter for the courts, but penalties are available, and in some cases can be quite substantial. That's one of the trends coming out of the Brisbane Registry of the Federal Circuit Court at the moment, is that they're handing out pecuniary penalties. So the availability of compensation for hurt and humiliation is the real benefit, I think, of general protections over, say, an unfair dismissal. So unfair dismissal actions, successful unfair dismissal actions, will never result in more than 6 months of the employee's ordinary wages and possibly reinstatement, but that cap on compensation is provided for by the legislation. There's just no way around that. So general protections is going to be a better option if you've got a large claim. Costs are usually not available, so that's really a big benefit of general protections over, say, Human Rights Commission matters. So human rights matters going into the federal court system or the Federal Circuit Court, you would expect costs to follow the event, whereas in general protections matters, it's very unlikely that costs would be ordered. So for our clients or people we represent, that's normally a really big benefit. Obviously, for people who are paying a lawyer to represent them, that's a bit of a pain. But for our clients, it's often a big plus for this jurisdiction. It's hard to tell, but I also think that costs in Federal Circuit, like general protections matters, it's no more likely that you would be ordered to pay costs in this jurisdiction compared with QCAT. That's as close as I can get to comparing the likelihood of costs in a Federal Circuit Court or in QCAT, and I think it's no more likely you'd be ordered to pay costs in this jurisdiction. All right, I'm going to talk a little bit about the process. Does anyone have any questions about the what we've talked about up to now? It's maybe a good time to just check in. I haven't seen any come up. All right, good-o, moving along. So there are different processes for breaches occurring during employment and general protections dismissal actions. If you are arguing both types of breach in the same action, you'll need to comply with the dismissal process with its various restrictions. For dismissal actions, applicants must first lodge in the Fair Work Commission. Proceedings must be lodged within 21 days of the dismissal taking effect. So this is the same time limit as for unfair dismissal proceedings. Once you're in the Fair Work Commission, there'll be a conciliation conference. If there's any issue of jurisdiction, that'll be dealt with at that time as well. The conciliation conferences in the Fair Work Commission are really effective at resolving disputes. In unfair dismissal, it's something like 80%. In general protections, it's somewhere closer to 60 to 70% resolve at the conciliation stage. and you can have a look on their website, as I said before, about what sorts of outcomes people are getting at that stage. If you haven't been through conciliation in the Fair Work Commission before, be prepared for a sharper and more robust process than what you would get in the Anti-Discrimination Commission or the Human Rights Commission. Typically, conciliation conferences will be on the phone. Conciliators can be really forward in this jurisdiction, and this can be confronting for self-represented people as well as some representatives, so it's worth preparing your client for the manner in which they may be spoken to during conciliation. The Fair Work Commission might list 3 conferences in a day for a conciliator, so they'll expect matters to be in and out in under 90 minutes most of the time. If the matter resolves at that point, the Commission can draft a settlement agreement. So just keep an eye on the document when it comes through. The settlement agreements that we've seen will often include as standard releases for lots more than's before the Commission. So just bear in mind that even if the Commission is drafting a settlement agreement, your client might ask you to have a look at it, and it's worth having a good look. Alternatively, if you've represented the person, you can draft a settlement agreement. Sometimes that's a better option. If a matter does not resolve at conciliation, a certificate will issue saying that the Fair Work Commission could not resolve the dispute by agreement. The certificate gives the applicant just 14 days to lodge proceedings in the Federal Circuit Court in relation to the matter. Non-dismissal matters can go directly to the Federal Circuit Court, although in practice most people start in the Fair Work Commission as it is less confrontational. If a non-dismissal matter goes to the Fair Work Commission and doesn't resolve, the Fair Work Commission's involvement just ends there. There's no certificate issued. The person can go on to the Federal Circuit Court at any time. The time limit for non-dismissal general protections matters is not stated in the Fair Work Act. We take it, therefore, to be 6 years, which is the usual time limit for contract disputes. This makes it the longest of all of the relevant time limits and well longer than an anti-discrimination time limit, which is generally 12 months. You don't have to be still employed to bring a non-dismissal action. It can be brought well after the employment has ended, so long as there's nothing about the actual end of employment in the claim. The 21-day time limit and the 14-day Federal Circuit Court time limit for dismissals won't apply. All right, so that's all I really wanted to say to you about the process. If you're going through this process, there's loads of materials on the Fair Work Commission website. The last thing I wanted to talk to people, we have got questions.
How would you calculate the amount of damages?
Okay, so the question is, how would you calculate the amount of damages for pain and suffering, and what is taken into account? And there's another question, which is, why is it so high? The amount of damages in these matters is I don't know why it's going up. I think it might have something to do with the general overall change to the range. So a lot of us have been working in the anti-discrimination jurisdiction. You get kind of used to a range of damages. It used to be we could confidently tell our clients, oh, you'll be looking at between $2,000 and $20,000 for your hurt and humiliation component. And then we had that case of Richardson and Oracle, which I think a lot of people are probably familiar with. It came down at the end of 2014, and which has been picked up in the various jurisdictions. So it was under the Sex Discrimination Act. It's been picked up in the various other jurisdictions where they look at similar things. And what that said was that range is just way out of touch with community expectations. The community really expects that where there's been discrimination or sexual harassment that has led somebody to have really serious, personal consequences, then the compensation range should reflect that. And so in that case, an original finding of $18,000 was overturned on appeal to $100,000 for hurt and humiliation. And what has happened since the end of 2014 is we've got an increase in the amounts of compensation across a whole range of jurisdictions. And I don't know whether that is all that's going on in the Fair Work Commission general protection space, but the amounts in compensation are usually reasonably strong, particularly compared with, say, QCAT. But we're really hoping that QCAT will get on board with Richardson and Oracle at some point. The but at the moment, unless somebody feels like being the test case in QCAT to try to get them to change their range, for us in Queensland, you would be looking at a better range of compensation in the federal circuit court under the general protections. And I don't know if that totally answers everyone's questions, but they'd look at the same sorts of things as you would expect to be looked at in any proceeding which looked at considered hurt and humiliation. So basically, we tell our clients that the more serious the conduct and the more serious the impact, the further up your compensation will go. So depending on what the employer has done and how that has affected you, your compensation will, be at the higher end or the lower end. It is not an exact science. It's really difficult. There's another question. Oh, sorry, Nick. Why is the rate of resolutions at conciliation so high? There's probably a couple of reasons. For unfair dismissals, it's because they're low amounts of compensation. So it's really easy to settle something if you're only arguing about $10,000. People would just pay it or give up. Either way, it's really easy to settle it. So I think that's why for unfair dismissal it's so high. I think part of the reason why it's high for general protections is that the conciliators are quite aggressive. So they will tell people, this is what's going to happen if you take this matter further. And really they pressure people to settle for things which, I'll reserve judgment in a recorded forum on that. The other question that's come through is how are decisions made at conciliation conference enforced? So decisions at conciliation, there's not decisions made at conciliation conference. So conciliation conferences, the outcome is an agreement between the parties. There's no decision-making function on the part of the conciliator, despite the fact that they might aggressively push you to go with a particular outcome. They don't make a decision. The parties enter into an agreement, and the agreement is normally drafted up into a settlement, a deed of settlement, or a deed of agreement, or some other document which can then be sued on as a deed. So it's enforced in much the same way as you would any other settlement. It's not registered anywhere, so it's not like under the Anti-Discrimination Act where they then register that in QCAT. You just get a deed of settlement with the terms in it, so you've got to be really clear with your client about what would happen if it doesn't get paid. Clients are terrified that that the employer is not going to pay. It's actually pretty rare that they don't. By the time they get to that point, they normally just pay. But it's just the regular deed of settlement. Are we right to move on to choice of jurisdiction? Are there any other questions? There was a big run on them. Got any more, James? Oh, yeah. Okay, so there's a very specific question come through in relation to sham contracting. I will talk briefly about sham contracting at the end, and maybe can we hold on to that question so that we can maybe talk about it when we start? Yeah. So just bear with us, Paul, and I'll try and come back to your question at the end, and if not, I'm happy to have a chat with you privately about it. So choice of jurisdiction. We've covered most of the factors that go to the difficult choice of when to choose general protections action if there are other options available. So I'll just quickly recap those points in a list. Before I start going through the list, which will have up on your screens, I will just clarify a couple of reasons why it's so important to be across this issue. Firstly, you can't argue both unfair dismissal and a dismissal in breach of general protections. You have to make a choice about that. The 21-day time limit makes it really hard to change proceedings later on. So there are provisions under the Act for transfer of jurisdiction, but they're just incredibly tricky and don't often work out. So choosing typically what ends up happening if you have to change jurisdictions, you've got to withdraw one before you lodge the other one. Once you've withdrawn it, you then don't have proceedings on foot. And if you're lodging the other one, you're going to have to be inside the 21-day time limit to get it in without having to argue a jurisdictional issue. So making the decision of which way to go at the outset is essential. If you are familiar with unfair dismissal, and most of us kind of get unfair dismissal, if you're across unfair dismissal actions, you will recognise by now that most general protections breaches resulting in dismissal will also be unfair due to the very wide definition of unfair in the Fair Work Act. The reverse is not always the case. But almost all general protections dismissal cases, unless your client was dismissed in the first, in the qualifying period, but outside the qualifying period, your client will generally have to decide whether to do the extra work and take the risk of a general protections case for potentially unlimited damages, or go with a much easier, but often vastly less lucrative unfair dismissal option. The second area in which choice of jurisdiction is really important is in discrimination matters. If someone is dismissed for a discriminatory reason, they may have all four of unfair dismissal, general protections, an anti-discrimination matter under state anti-discrimination legislation, and a discrimination action under one of the Commonwealth Human Rights Acts. All of these jurisdictions naturally prohibit a person from bringing an action that is dealt with elsewhere, so starting correctly is essential. Some jurisdictions will let you go if you've started elsewhere but you've then withdrawn before it got dealt with, but others, like the Human Rights Commission, doesn't even take complaints if it's been complained of elsewhere. So starting right, and also clients get really confused if you later on advise them that maybe they should try somewhere else. So starting right is essential, and I think it's the most cost-effective way that we can help our clients from our own perspective as well. So briefly, the factors that might influence a client's choice of jurisdiction are how well the client's facts fit the law. So if it's not completely clear why the decision to dismiss was taken, would unfair dismissal be a safer option? So how well you fit with the law, that's pretty obvious to most of us. The available remedy range and whether the client's got evidence that might assist them get a larger amount of compensation if they bought it in a more generous jurisdiction. The risk of an adverse cost award if unsuccessful, or if they're represented, the availability of a cost award if successful. Would the reverse onus help in any way? How might the client fare in the conciliation conference process? Do they need the care and attention of a Human Rights or Anti-Discrimination Commission conciliation process? Because anyone who's been through the Queensland Anti-Discrimination Commission conciliation process will know that it is very caring, it's very generous, there's lots and lots of time, your client will really get the opportunity to be heard. You don't get any of that in general protections. What's the time limit? So have any of the options already expired? That's pretty obvious. If a client comes to you and it's been a couple of months since they were dismissed for a discriminatory reason, that might make the Anti-Discrimination Commission more attractive as compared with the Fair Work where you've got 21 days. Eligibility criteria more generally, and whether or not all the client's problems can be collected together in a single legal action. If you can, generally you will collect them all together. So there is a table. Now, James, I need James to help me send you this table. This table was produced, oh, can they see that then? Oh, so this table, I'll scroll down it so you can have a quick look at it. I'm going to send it to you, so don't feel like you have to memorise it. So this is from Legal Aid Queensland. This was prepared by Legal Aid and partly by me when I was at Legal Aid. Fiona Muirhead, who's the principal civil lawyer at Legal Aid, sent this, said I could send this to everyone, but I had to make it absolutely clear that they had to exercise their own judgment when you're talking to the clients about the matters in this table, because you can actually give this to your clients. You can print out these 5 pages, you can circle the bits that matter to your individual client, and you can give it to them to take away and think about. So it goes through initial complaint, where it goes to the legislation, the forms, and then it starts to take you through the factors that speak to one or the other jurisdiction. So what's the process like? What's the time limit? Where does it end up? Can you get a lawyer represent you, as of right or not? Here's your remedy range. The risk of costs and the cost rule. There is also, just while we're in here, because you're all going to want the one with the footnotes as well if you're going to use this table. There is another version footnoted for lawyers so that you can check the section references if you're that way inclined. But so back to, they've got the cost rule, they've got if there's multiple reasons for the adverse action or less favourable treatment, so how do you, what's the various thresholds, the burden of proof and how, what might be relevant reversals of that. We put in what we, the speed of process is really just a judgment call, and it's sort of a relative speed of process. At the moment we'd be saying that QCAT's probably the slowest, but actually they've just changed their procedure for discrimination matters, which I think is speeding them up a little bit. So, you know, that you've got to keep on top of this, things like that, amounts of compensation, and hopefully we're really hopeful that this bit here, QCAT compensation amounts, that we're hoping that QCAT will see the light at some very soon point, and that will change. But at the moment, QCAT is probably your lowest. The next bit of ease of use, that's just our kind of feelings about it. In the one that we initially prepared, it was a little, there was a bit called, you know, tone of the jurisdiction, how we feel about it. But Lucy, if anyone knows Lucy, who used to work at Legal Aid, she's much more kind of cautious, and she's changed it to be ease of use. And where people can find more information about the various jurisdictions. So if you have a client who's, let's face it, we're talking about relatively sophisticated clients, but if they're going to self-represent in general protections proceedings, they'd want to have a capacity to get across the law. So if you've got a client who's relatively sophisticated, you can print this out, circle the things that they tell you, I can't risk a cost order. It's taken me 20 years to buy the house I have. I just can't risk a cost order. Then you can, you know, circle for them where that's relevant, so that they can remember why they made the decision to go with whichever jurisdiction they choose. So you'll all get this somehow. James will make it happen for you. It's a really handy tool. The other thing, of course, is your own experience. So ask yourself at the moment, how do the different jurisdictions feel? Are they on top of their workload? Do they have a generous attitude to the kinds of things I want to raise? Are they pressuring people to settle, and so on? Those things you can't get on a grid, but they're all really helpful. At this point, what I had left to do was just talk you through some client issues. Now, I don't know, we're right at the end of our time. We started a bit late due to some technical hitches on our end. Perhaps I might keep going for a couple of minutes, and I will not think less of you if you just disappear. So maybe I'll just cut down to doing one case study instead of 3, and we'll see how we go. So in this case, hang on, I might pick the second one, just the second one. So this client of mine had a very serious mental illness, which included, on at least 2 occasions, psychotic symptoms. So the first psychotic episode was many years ago, like 5 years ago. Then got a job with this large employer, had told them all about his condition, but because he was asymptomatic for a really long period, it just never came up. He became ill. He had some insight early on, early on in his episode of illness, and he went home sick. But as he became increasingly unwell, he lost all insight. He did some things that were fairly offensive to his HR manager, but none of that was at work, and there was no threat of violence. He was sacked for misconduct. Basically, he was sacked for conduct that was a manifestation of his known disability during a period of acute unwellness when he was off work. So this guy had all 4 options available to him. He could have run an unfair dismissal option, a general protections action. He could have done an anti-discrimination or a disability discrimination action. So anyone who's done any ADA or DDA work will know about Purvis decision and the comparator, which meant that those options were not good options for him. The manifestation of his disability problem meant that if anyone else had behaved in that way, they also would have been sacked. So the Purvis matter was fatal to any action under the disability discrimination legislation. He had been sick for a really long period of time following the dismissal and couldn't have worked in any event. So his financial losses in the 6 months following dismissal, so the sorts of things you can get compensation for under unfair dismissal, were minimal, which meant that general protections turned out to be the best option for him. If he'd gone with unfair dismissal, he just wouldn't have got a remedy. He probably would have been successful, but he wouldn't have got a remedy. So general protections gave him the best way of going forward with that case. So you can see from that example the sorts of things that go towards jurisdictional choice. Look, that's probably enough. I'll send you my material. Apart from that one question, Paul, and I think maybe now we are going to have a private conversation about that. Is there anything else that before? So if anyone wants to quickly throw up a question. Oh, someone generously said feel free to keep talking. Oh, Melissa, of course. No worries. All right. Well, thanks everyone who stuck around for the whole thing. And I hope that that table is useful to you and you will receive my notes via email, I imagine. Do you want to go back on, James?
No, you can say goodbye to everyone.
All right. Thanks, everybody. Goodbye.